Mr. Lim, Biow, Chuan.
Mr. Deputy Speaker, allow me to declare my interest in speaking on this bill as the President of the Consumers Association of Singapore, or CASE for short. In the second reading of the Small Claims Tribunal Bill in 1984, the then Second Minister for Law and Home Affairs, Professor S. Jayakumar, said that the primary purpose of this bill is to provide for a speedy and inexpensive machinery to handle small claims arising from disputes between consumers and suppliers. After 34 years, this rationale still holds true today. Every year, CASE receives many requests for assistance from consumers whenever they have disputes with businesses. And wherever possible, we strive to mediate a settlement between the parties. However, in some cases, a mediated settlement is simply not possible because of the different expectations between parties. In such cases, where the disputes concern a lower quantum below 10,000, referring consumers to the SCT allow them to have their dispute adjudicated in a speedy and inexpensive manner. And that is the thrust of what the Small Claims Tribunal is about. Hence, CASE supports the extension of the jurisdiction of the Small Claims Tribunal to 20,000, and the prescribed extended limit is increased to 30,000. CASE is also supportive of the increase in the limitation period from 1 to 2 years. These amendments will widen the jurisdiction of the Small Claims Tribunal and enable more consumers to have access to the Small Claims Tribunal to seek a fair decision in their disputes. The alternative is for consumers to engage their own lawyers to argue their case in court, and this will invariably result in higher legal costs. So allow me to raise 3 issues for consideration. There has been feedback from consumers that when they bring their cases to the Small Claims Tribunal, sometimes decisions made by the referee will not explain clearly to the consumer. The end result is that consumers have no idea as to the reasons why their claims were dismissed. Sometimes they feel aggrieved at the perceived injustice. It also affects their decision whether to appeal to the High Court if they are still dissatisfied with the decision. Could I urge the presiding judge of the state courts to ensure that all tribunal magistrates appointed to hear disputes at the Small Claims Tribunal are not only legally qualified personnel, but also experienced officers who are trained to deal with members of the public who are not conversant with legal principles. As the SCT will deal with large numbers of public, this will allow the public or businesses to better understand the reason why their case was not successful. The next issue concerns the jurisdiction of the Small Claims Tribunal, which was previously defined under Section 5 of the Small Claims Tribunals Act. Recently, when OBITE announced that they were ceasing to operate in Singapore, many consumers wanted to submit their claims to the Small Claims Tribunal to ask for the refund of the rental deposits. However, Section 5 of the Small Claims Tribunal Act does not provide for claims for refund of rental deposits, nor would it be considered provision of service as no skill or labour is involved in the supply of such rental bicycles. May I urge the Ministry to consider reviewing all common consumer claims and to expand the jurisdiction of the Small Claims Tribunal to cover more common consumer disputes. Finally, sir, last year, during the Committee of Supply debate on consumer protection, I spoke on the need to ensure that consumers are protected when making purchase transactions online. The research by CASE shows that there are several companies which provide for arbitration clause in their online standard terms and conditions. Now, this means that consumers who buy online would have to agree to arbitration when transacting with these online companies. These consumers have no negotiating power to ask for the arbitration clause to be removed. Thus, for example, if an online business makes a consumer sign up as a customer and impose a monthly charge without the consumer's consent, this may be an unfair practice under the Consumer Protection Fair Trading Act. But if the company is unreasonable, the only way for the consumer to seek legal recourse may be to go for arbitration, even if the business is clearly engaging in unfair practice. So you can't go to SCT to seek redress. Because of the arbitration clause, the consumer has no choice but to refer the matter for arbitration. In the recent case, when CASE wrote on behalf of consumer to a company regarding a defective furniture worth $1,134, the company declined to go for mediation. And what did the company do? The company asked consumer to seek legal redress by going to the Singapore International Arbitration Centre for the settlement of the dispute, a dispute of $1,134. So in reply to my speech last year at the Committee of Supply debate, Senior Minister of State, Mr. Koh Poh Koon, said that in line with the principle of the freedom of contract, businesses are free to enter into consumer contracts as long as it is mutually agreed to by the contracting parties. With greatest respect to SMS Co, this misses the point of why the Small Claims Tribunal was set up in the first place, which is to protect consumers and to ensure that consumers have a speedy and inexpensive way to resolve disputes. The reality is that most consumers do not read fine terms and conditions of a thick set of contractual terms when they buy something of low value. For the government to expect consumers to knowingly agree to arbitration for contracts of a small value is unrealistic because the cost of arbitration is very high. If the government is intent on protecting consumers from being taken advantage of by unscrupulous businesses, surely we can specify that businesses cannot oust the jurisdiction of the Small Claims Tribunal for claims that is clearly within the jurisdiction or the prescribed limit of the Small Claims Tribunal Act. So I urge the government to rethink this point and not simply assert that consumers are free to contract. The Unfair Contracts Term Act is would also have no meaning, as businesses which impose unfair contractual terms can assert that businesses are free to enter into consumer contracts as long as it is mutually agreed to by the contracting parties. Hence, I urge the Minister to consider inserting a new clause to amend the Small Claims Tribunal, the Small Claims Tribunal Act. We should not allow business to oust the jurisdiction of the Small Claims Tribunal by referring disputes within the specified limit for arbitration. With this, sir, I support the bill.